Hello everyone, welcome back to Educational Express. In today's video, we are going to discuss an important topic from business law, discharge of contract. We will understand what it means and learn about the different ways in which a contract comes to an end. If you're new to this channel, don't forget to subscribe for more easy-to-understand educational videos. Now, without wasting any time, let's begin. What is discharge of contract? A contract creates legal rights and obligations between two parties. When those rights and obligations come to an end, and both parties are no longer legally bound by the agreement, the contract is said to be discharged. In simple words, discharge of contract means the termination of a contract, freeing both parties from their legal responsibilities. Modes of discharge of contract. There are 6 major modes through which a contract can be discharged. Let's understand them one by one with simple examples. 1. Discharge by performance. This is the most common and ideal method. It occurs when both parties successfully perform their promises. There are 2 types. Actual performance. Both parties fulfill their obligations completely. For example, a buyer pays for a laptop and the seller delivers it. The contract ends successfully. Attempted performance, tender. One party is ready to perform the contract, but the other party refuses to accept it. In such a case, the contract is considered discharged for the performing party. 2. Discharge by mutual agreement. Sometimes both parties mutually agree to end or modify their contract. This includes novation, replacing the old contract with a completely new contract. Alteration, changing certain terms while keeping the same parties. Rescission, canceling the contract by mutual consent. Remission, accepting a lesser performance than originally promised. For example, accepting 8,000 rupees instead of 10,000 rupees as full settlement. Waiver, voluntarily giving up a legal right. Merger, when a lower right merges into a higher right. For example, if a tenant purchases the same house he was renting, the tenancy contract automatically ends because he becomes the owner. 3. Discharge by impossibility of performance. This is also known as the doctrine of frustration. If an unexpected event makes performance impossible or illegal, the contract comes to an end. Examples include destruction of subject matter. A banquet hall booked for a wedding catches fire before the event. Death or incapacity. If a famous singer is hired for a concert but dies or becomes seriously ill before the performance. Change in law. A new government law makes the agreed activity illegal. In all these situations, the contract is discharged. 4. Discharge by lapse of time. Every contract has a legal time limit for enforcement. If a party does not take legal action within the prescribed limitation period, the contract becomes unenforceable and is discharged. 5. Discharge by operation of law. Sometimes the law itself terminates a contract. This may happen because of death in contracts involving personal skill, insolvency or bankruptcy declared by the court. Merger of rights under law. 6. Discharge by breach of contract. When one party fails or refuses to perform without legal justification, it is called a breach of contract. There are 2 types. Actual breach. The party refuses to perform on the due date. Anticipatory breach. The party informs the other side before the due date that they will not perform the contract. So these are the 6 important modes of discharge of contract. I hope this explanation helped you understand the topic in a simple and easy way. If you found this video useful, please like and share it with your friends. Don't forget to subscribe to Educational Express for more educational content. Also, tell us in the comments which business law topic you would like to see next. Thank you so much for watching, and I'll see you in the next video.